Just because the Supreme Court of the United States overturned it, it doesn't mean the state Supreme Court thinks the same way, nor is going to come to that same conclusion.
All right, we're back. Welcome to the Law-ish Podcast. Another day, another episode.
That's right.
And today we have it's almost like a follow-up of a conversation we had back to episode 1. If you recall, for those of you that have been following us, the 16 of you that
Our loyal followers, it's actually 17 right now.
Oh, 17. Oh, we have 17 subscribers.
So,
Thank you.
Not the brag. But.
Yeah. Hey, listen. These are milestones. So for the 17 of you that have been following us since day one, our day ones.
That's right. A1s.
Yeah. Yes. With the first episode we did, because again, we're masochists, was the Dobbs decision. And that is the decision that overturned Roe v. Wade. Well, as you can imagine, there have been some developments ever since that decision came out, because effectively that decision it's up to the states.
Yeah.
Well, a lot of states created what these are what they're called trigger laws that ban abortion, and they were designed for the most part to come into effect if and when Roe v. Wade was overturned.
Yeah.
And I say if and when because, for example, one of the ones we're going to discuss today, which is North Dakota, was in the books in 2007. And saying this is a law we are enacting, we're putting in the books for when Roe v. Wade is overturned, meaning they had their hopes up that this was going to happen eventually. So this episode, we're going to focus on a couple of developments that have happened since the Dobbs decision and at the state level now. Because, again, that decision left it to the states to decide whether they want to give to their residents the right to have an abortion.
Yeah.
So why don't you get us started, Jeff?
Well, it's kind of interesting. Trigger laws themselves. It's basically legislatures are enacting laws that aren't legal because the law, at least in this case of the Supreme Court, and contradicts the law they pass. Now. That's why it's called a trigger law. It's
like
not
optimistic laws.
Yeah.
Like wishful thinking laws.
But it's kind of like, how can a state legislature pass a law that's not legal proactively? And nonetheless, I don't think it's really been challenged yet. But anyway, yeah, like you said, they don't take effect until if and when whatever event happens. In this case, that's blocking them from being legal, which was, in this case, Roe v. Wade. So
there's like a condition precedent to the law coming alive.
Which is kind of interesting as well, because it brings into, kind of question things about notice and whether or not these are constitutional in the sense that there was no actual hearings done. They were all done prior, years before, potentially sometimes.
In North Dakota's case, it was over 10 years ago.
There's no notes and comments. There's no ability to actually say anything. You just wake up one day and boom, all right, it's illegal now. So, that's potentially, I could see these getting challenged, but that's not really kind of what we're here to talk about today. But nonetheless, there were numerous states that enacted these. A lot of them were relatively recently.
13 to be exact.
13 states. And so as soon as Roe v. Wade got, overturned, they went into effect. Well, at least that was the goal. What we see now is there were several abortion clinics or other individuals who were obviously, pro-choice that challenged these laws. And so these cases went up to various district courts. Several judges found that they were unconstitutional. Now,
based on here's the kicker:
the Constitution,
the state's Constitution.
State Constitution, yeah.
And now, so the latest developments on that front come from North Dakota and Wyoming.
Yeah,
like you said, there have been abortion clinics and pro-choice advocates who sued these states now because then the fight moves from the federal level to the state level, and the latest developments come from North Dakota and Wyoming, who join 3 other states, Kentucky, Louisiana, and Utah, who have also been having some of these fights, where in these states as well, there had been at least temporary restrictions on the enforcement of the trigger laws.
Yeah.
And that effectively, at least for now, I mean, these in North Dakota and Wyoming happened in July 27th, so a few days ago. And that effectively essentially stops the enforcement of the laws, which means, at least for now, abortion clinics can continue to operate and people within the state can continue to seek abortions legally.
Yeah, it just stays the law, basically. So it goes to essentially until there's determination is made that Roe v. Wade is, well, effectively still, in place. Now, it's not Roe v. Wade that's actually in place, but the basically outcome or what was happening in Roe v. Wade, the same kind of framework a lot of states adopted after Roe v. Wade went into effect in their own constitutions. And it's important because it comes back to kind of what we touched on again in Dobbs and when we were going through Dobbs, something called the Supremacy Clause, which is in Article 2. It's basically saying that, if there is a conflict between a state law and the federal law, that the federal law takes precedent over the state law. But also within that, there's a hierarchy of, within our system, our judicial system, and our legislation, everything else, hierarchy of kind of who does what the branches of government do, what takes precedent in certain situations, and brings us back again to Marbury v. Madison we touched on previously, which is a case that determined that the ultimate decision maker as far as interpreting what the law is, not making the law itself, but interpreting what the law is the Supreme Court. So Congress passes a law or state legislatures pass a law, and the Supreme Court then interprets what that law is. They have the final say. It becomes the law of the land. Now, we're in an interesting situation here because you have the Supreme Court, again, leaving it up to the states. Okay? And then we have these trigger laws.
And the funny thing is that becomes the law of the land. The law of the land is the states decide.
Yeah, and so
but then within that you have all the states which have their own laws.
Yeah, and the states like, great, our legislation, we had these trigger laws in place. We already decided, potentially years ago, that this is what was going to be the outcome, which again calls into question the constitutionality of these laws anyway. But they, Congress does this, but then who interprets that, right? Who interprets what that law is or what the law is within that state? Well, the Supreme Court.
Of the state.
State.
Well, the judicial system of the state.
Yeah.
Right? Meaning the district court, circuit courts, and Supreme Court of the state.
So, yeah, it's interesting. So it's the Supreme Court again, but it's a different Supreme Court. It's the Supreme Court of the state that the U.S. Supreme Court said has the say in what happens with abortion. Why it is, important and what the kind of the argument here is with the district court judges that are at least staying temporarily these laws, they're saying it's in conflict with the state constitution, a lot of which interpreted their own constitutions, interpreted the right to privacy, the right to a woman to choose whether or not to have an abortion, the same way the Supreme Court of the United States did. But just because the Supreme Court of the United States overturned it and said, well, they got this wrong, it should have never been this way, this, that, or whatever, based on our textualist interpretation, that doesn't mean the state Supreme Court thinks the same way, nor is going to come to that same conclusion. So
yeah, and that is because the decision of Dobbs is we're going to wash our hands. The states decide.
Yeah,
and that means their states have their own stare decisis and their own history of precedent.
Yeah.
That they have seen throughout the years ever since the state decided at one point or another to find that the right to abortion was enshrined somewhere in their state constitution. Before even Roe, maybe, and that could mean that when, not if, but when, because these judges that have been essentially issuing these temporary stays are district judges. That means it's going to go through the appellate process, and that it will find inevitably its way to the Supreme Court of the state. Well, that still means it's essentially a do-over within the state, where the state Supreme Court could say, you know what? State precedence says that abortion is found within our state constitution, and in order for you to make abortions illegal in this state, you need to change the constitution.
Yeah,
and that is a whole different process.
Yeah.
Now, one thing that we must say though is, as opposed to the U.S. Supreme Court, state Supreme Courts are elected. Mm-hmm. The U.S. Supreme Court are lifetime appointments. The intent for that was, if you have a job for life, you're not pressured into making political decisions or feel swayed by political climate. Whether that happens or not in reality, that's a whole different question that I'm
There's
not
definitely ups and
qualified to
downs.
answer. Yeah. But as opposed to that framework at the federal level. On the state level, Supreme Court judges of the state level are elected,
Yeah.
which means technically they are prone to that swaying of opinions in order to, appeal to essentially the people that elect them.
Yeah, and so that kind of brings us, to where are we going? Where could this potentially go? And I think it's, obviously it's that ruling's going to be challenged. It's going to get appealed. It's going to, at some point, make its way up to the Supreme Court, like you said. They're going to make a decision. They could very likely say, "Oh no, it's not. We're taking the same stance as the U.S. Supreme Court. That's the end of it. Nothing else. It prolongs it. It stays the law. It allows people to who are pro-choice to still get abortions in the process. But it could very likely also, they do interpret the state constitution, like you said, as being." This is against the state constitution, that there is a right to for women to choose what to do with their body and if they want to get an abortion. If that's the case, we're in a much more interesting place, because what are they going to do? Challenge it to the U.S. Supreme Court? And what's the U.S. Supreme Court going to say? They already said it's up to the states. Yeah. And if you want to have legitimacy as the Supreme Court and say we're the ultimate deciders of what happens, how are you going to take that power away from the state Supreme Court to do the same thing?
Would you just gave them the power and said, all right, it's up to you.
Exactly.
And then say, okay, I decide this.
So,
no, that's not how you should.
Yeah. The reality is they would have to amend the Constitution. But then the kind of argument that the pushback on the other side is, once these were challenged, was a lot of these don't explicitly say, obviously there's a right to an abortion. It's read in the same way it was in Roe v. Wade. So that brings into question what they would have to do if they amended it. Are they going to explicitly say abortion's illegal in the Constitution? Because if they don't do that, and the Supreme Court's interpreting it in this way, it's not going to really change, right? So,
that's technically what you would have to do.
Yeah,
you would have to, especially if it's found in a substantive process within the state.
Yeah,
that means it's not explicitly written, right? And that means you have to explicitly carve it out now.
But I think the other thing is too, it's going to be interesting to see is if it got to that point, what the legislation in the laws who enact in the states that enacted these trigger laws previously, years ago, what their stance is now, if that changes potentially, and then even if not, say they amend the Constitution, and it changes it or whatever, or the states where they say, no, it's whatever, they allow it to go into effect. I think there's going to be a challenge to the trigger laws themselves. I do think there's an argument that those are unconstitutional, and I could see that going up to the Supreme Court as well. And honestly, I don't know. I could see the U.S. Supreme Court saying these are unconstitutional. Now, the state could easily just implement a new law.
Right.
So again, all this is doing is prolonging essentially the inevitable, I think, in a lot of these situations. But for the state Supreme Court saying, well, even then you could amend the Constitution, but still, that would significantly prolong it, potentially in some of these situations. And that's not easy to amend the Constitution in anything.
Oh, yeah.
Any regard, even at the state level. So that could potentially prevent, in some of these states where there is support, but not enough support to get a constitutional amendment passed, it could have implications where, it prevents some of these states from enacting anti-abortion laws. But it's going to be interesting.
And the main point being that this is not a done deal.
No.
For either side. Because if you are someone who's pro-life and you just want to essentially make abortion illegal, there are the means to do it.
Yeah.
It's just gonna have to be through the proper ways, because again, the Supreme Court did not make abortion illegal. It just said it's not in the U.S. Constitution. It's up to the states.
Yeah.
Well, then the states enact those trigger laws. If the trigger laws are challenge unconstitutionality of the state, you still have to go through those proper means and determine its legality. And if the way you drafted it is wrong because of this X, Y, and Z, then you go back to the drawing board and then draft it in a different way.
Yeah.
To your point, if you are pro-choice, what this gives you is the chance to live another day and fight another day. But all it comes to show is that it's not a done deal either way.
Yeah, and it's kind of, I don't know, it's interesting, if nothing else, because I don't think the Supreme Court of the United States really even interpreted kind of this happening. And, I guess you would think they would, but I think almost they were like, oh, Congress will make the decision in these states, not really expecting the potential challenge from the Supreme Court within that state to really contradict Congress or what Congress was saying.
Well, yeah, but then at the same time is if the Supreme Court says, the U.S. Supreme Court says, except to the states.
Yeah.
Well, the states are their own
Oh, no.
their own living entity, and that means it's not up to the Congress of the states. It's not up to the U.S. the Supreme Court of the states, redundancy aside, but it's to the states. Like, you figure it out, and that means your executive, your legislature, and your judicial system. You figure it out. It's not in the U.S. Constitution.
Yeah.
So I think that opens the door. The U.S. the decision does not say, well, what is the state. Obviously, we know what a state is, but do I mean the state Congress? Do I mean the state judicial? Do I mean the state executive? The checks and balances we have at the federal level, we have the same thing at the state level.
Exactly.
So then that means in a state, as a legislature, you have to propose a law. The law is a bill. It goes through the House of Representatives of the state. It goes through the Senate.
Yeah.
And if it goes to the governor signs it. If someone challenges it, it goes to the courts.
Yeah.
And that's essentially what happened, right?
And then
you have a trigger law
Yeah.
proposed by the legislature, Congress overall, goes to the governor signs it, and guess what? Well, some of these abortion clinics or pro-choice advocates challenge the law. It goes to the state, and the state says, for now, it looks like this is not constitutional. We're going to stay it.
Yeah.
That is literally the process of the states working it out per the instructions of the U.S. Supreme Court.
Well, and that's the most interesting thing. Even if the U.S. Supreme Court wanted to do something about it, they couldn't. You can't say, "Oh, Congress has more power than your state Supreme Court," or over the Constitution like that. Then you're just contradicting your own power within your own argument because it's the same system just on the state level. So, yeah, it's interesting. I think another thing I just want to touch on briefly, I think is also interesting is the Department of Justice has been talking about Congress codifying Roe, and there's been questions and pushback on Garland about whether or not that goes against the U.S. Supreme Court. He argues it doesn't. He says, Congress said, or they said it was up to the states. His point, which I think is a valid point, but also does, in a way, at least go against the intent of the Supreme Court, was the supremacy clause. He said, yes, states can pass their own laws, but if the federal government, being Congress in this situation, passes a law that's in conflict with the state laws, it takes precedent. Obviously, it's going to get challenged. But I think he's got a point in that regard. So, I don't know. I mean,
I think he's got a point also on a separate regard, which is the decision for Dobbs saying it's up to the states was because you couldn't find a fundamental right to abortion in the Constitution. Doesn't mean you cannot have that right explicitly given by the U.S. Congress because Congress can make the laws.
And
if it's explicit enough, it's on there, right?
Yeah.
I think your point still stands where it's like, well, it's still going to get challenged because the court is saying it's up to the states. The legislature is like, well, we're relying on the supremacy clause to then trump those states. I'm oversimplifying this, but I think it may come to the timing.
Yeah.
So at the time of the Dobbs decision, the Supreme Court goes back to the states. The states then create these laws, but then at a later time, if the federal Congress creates a law, even if it were to go back to the Supreme Court now would have to recognize there is a federal law. There's precedent based on the federalism. Now it may turn a different way because now there is at least a law in the books. Maybe not in the Constitution, but somewhere else.
I agree. And because there's no argument to be had that the Constitution says you can't have an abortion.
Right.
It'd be different if
But you can make a law to make
it'd be different if this amendment in the Constitution says abortions are illegal. Okay, well that would contradict and the supremacy clause, whatever, but there's not. So that would certainly be higher. The federal government certainly is based on the supremacy clause. And ultimately too, I don't really know that it necessarily does go against that because who elects the members of Congress? People in the states. So I think there's state representatives within Congress. I think there's still an argument that it also is, but it doesn't matter anyway. Like you said, I think if Congress were to do it, unless the Supreme Court wanted to be extremely political and find some really weird way to try to, overturn it, I think absolutely it would take precedent. But the issue then comes down to kind of what we talked about before is it going to become this political fucking, pinball, basically. That's whoever's in power is going to pass a law and change it, and it's just going to be a nonstop back and forth.
It's not easy to amend a state constitution. So you would have to have a huge swing of the pendulum to then have all the systems in place to change the state constitution.
I mean, on the federal level. I'm saying I was talking about the federal level.
Okay, I wasn't paying attention.
You're good. No. Yeah.
There's still plenty of road for us to go through, and what's going to happen most likely, these states, the district judges have stayed the trigger laws. That is going to find its way through the appealing process up until most likely it reaches the state Supreme Court, and then that's where we're going to see what happens. Even if, as we discussed throughout this episode, even if the state Supreme Court says this is unconstitutional because of our state constitution, then you still have the avenue of the legislature having enough votes or people on board to change the constitution. And if that changes, that is also going to get challenged.
Yeah.
And we might find ourselves in the same spot, in a few months, in a year, who knows.
Yeah.
So,
and you have the potential challenge of the trigger laws themselves. So
exactly.
all these, if nothing else, is going to be delays, significant delays potentially in these laws going into effect. So
this one was a little bit of a shorter episode. Hopefully you liked it. We'll keep you posted on any developments that we hear in these states. We just thought it was definitely worth revisiting this because it's essentially the developments of our first episode, and it obviously is relevant.
Yeah, and I think for a lot of people it's probably unexpected. So it's going to be interesting, absolutely, to see how this plays out. But we'll have to see, I guess.
Yeah, we'll keep you posted. Thank you again for joining us. This was Lodge.